Hi, good afternoon, everyone. Thank you all for coming to today's talk on AI and law organized by Bidhi Talks. Um, we all know about artificial intelligence, and the topic for today speaks on its own. And traditionally humans are supposed to have the intelligence to create and innovate and everything, and that is protected as per law, and all innovations are also recognized as per society and even laws. But in today's world, we've seen a lot of artificial intelligence also innovating and creating, and the whole discussion today is going to be around that, as to why that intelligence should not be recognized and protected and channelized, and for us as lawyers to exploit that to our advantage. So it's the three of us today, Imran, Gurpreet, and I, will be talking about this, and it's an open discussion, and we would want to make it interactive, and we'll have a question and answer session at the end as well. So Gurpreet is going to lead the discussion and start. And I want to introduce Gurpreet. He's an advocate with more than 10 years of experience in litigation across North India. He's a graduate of Symbiosis Law School, Pune, with an LLM from Columbia Law School, New York. He's based in Chandigarh and specializes in IP, technology, and commercial litigation. Over to you, Gurpreet.
Thank you, Jasneet. Very kind introduction. I think before we get into the meat of today's discussion, and I will try to not make it a dry introduction with a lot of definitions. A certain amount of that will be necessary because I understand AI itself is a topic that's probably new to a lot of people, or at least the technical definitions of what constitutes AI is new. But before we get into that, what I thought we would do is just give you two examples. One is an artwork. I think a lot of you already have printouts of what that artwork is. The other one is an audio clip. So if I can just ask everyone for about a minute's worth of patience, I'll just play this clip, and then I'll explain how both the artwork and the clip relate to today's topic.
Into how to make India developed by 2047, I am rather curious to contemplate on the questions of development. What is it? What does it mean for an individual to develop, a region to develop, and a nation to develop? Starting with you, Mr. Prime Minister.
Thank you, Manjari, for such a gracious introduction to this thought-provoking dialogue. It is indeed a privilege to participate in this virtual confluence of ideas with the esteemed F.A. Hayek, under the auspices of the Friedrich Naumann Foundation and Thoughtika's cutting-edge technology. Your question, delving into the multifaceted concept of development, evokes profound contemplation. In my view, development is an encompassing journey towards a society where scientific temper and rational thought flourish, unfettered by the shackles of obsolete ideologies and practices. It is not merely an economic phenomenon, though economic progress forms a significant part of it. Development is an integrated process involving the upliftment of the human spirit, the broadening of perspectives, and the betterment of the quality of life for every individual.
Right, so I don't know if anyone recognized who the second speaker was, but the voice that you heard is, as best as I can understand, the voice of Jawaharlal Nehru. And the first voice that you heard, you'll be surprised to know, is not a real person. This was a clip from a podcast that was released a couple of months ago. The entire podcast was generated by AI. The moderator who you heard speaking in the beginning is not a real person. Her voice, as far as I can understand, is a made-up voice. There's no person in the world with that particular voice. The audio recording of Jawaharlal Nehru that you heard was based on training of audio clips of Nehru that was fed into an AI model. There isn't time to play the entire podcast, but subsequently there is a discussion between Nehru and an economist by the name of Friedrich Hayek, on what constitutes development and development for India projected forward to 2047. So this is just an example of the power that AI has, AI of course being artificial intelligence. You can, using an AI computer system, generate an entire discussion on a contemporary topic by two historical figures who, by all accounts, didn't meet, or if they did, they certainly didn't have the discussion that we were hearing in that audio clip. So that's just a little bit of a thought-provoking example on what AI can do already, not just in the future, but what is it doing actually right now. The second one is perhaps a little more relevant to people. I've given you all, or rather we've given you all a printout which has three pictures. The picture on the left is a photograph taken by a living person. The picture in the middle is a digital copy of Vincent van Gogh's Starry Night. And the picture on the right is the result of the first two pictures being fed into an AI computer model with the prompt that a new image should be created based on both of those two. This was done by, in fact, a lawyer based, I believe, in Delhi by the name of Ankit Saini. The name of the resulting picture on the right-hand side is called Suryast. And Ankit Saini attempted to get that picture copyrighted. Even though he did not draw the picture on the right, that picture on the right was generated entirely by an AI computer program on the basis of the two pictures that were given to it beforehand, the pictures on the left. Initially, when he filed his copyright application, it was rejected because he filed it giving his AI model, which he called Raghav, as the author. He subsequently refiled it, making himself the co-author with the AI model. That was apparently granted. There is some confusion. I think Jasneet will probably be able to speak to what is the current state of copyright protection for this picture. But what's important to understand in this is that today, AI is producing new and original text. AI is producing new and original audio. AI is producing new and arguably original art, like the one that you have printed in front of you. And of course, some of you may have seen already online, there are deep fakes, which are audio-video clips also. So now, in that context, why are we discussing this today? While doing a little reading for this session, I came across the Model Rules of Professional Conduct published by the American Bar Association. So what the model rules say is that a lawyer must maintain requisite knowledge and skill and keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So I think the first part of that quote, most people will agree we all try to do. You should have requisite knowledge and skill as a lawyer. The second part also, we should know changes in the law. You should keep yourself abreast of that. But the third part is, I think, what we would like to try and introduce to everyone and ask questions, in fact, of you. Are you doing anything to understand the benefits and risks associated with new technology in the field? And I think, as Imran will probably introduce to us, that technology is already available to us. AI-powered technology, AI-assisted technology, those tools are already with us. They are not just making artworks and video clips, they are already in a position to assist lawyers. So keeping this framework in mind, what we would like to try and do is try and help you understand what are the benefits and risks associated with this topic. I'm sure some of you are already using tools like ChatGPT or Gemini to assist in drafting or research. Clearly, those are benefits. There are, of course, as I said, certain risks. There was a case, I think Jasneet might elucidate on that more, in New York, where lawyers submitted a legal brief before a court using ChatGPT to produce the research, and it turned out that what is known in AI language as an hallucination occurred. The legal brief that they used contained a citation which was completely fictitious. It was completely generated by, I believe it was ChatGPT. I don't want to defame any particular AI tool today, but I'm sure if you look it up online, you'll find all the details, and maybe Jasneet will elucidate a little more on that. So before then we get into how we'll try and frame what the next two speakers will say, I'll just try, for those of you who are maybe not that familiar, to explain some of the jargon, like what is AI, what are LLMs, that's another term that we hear bandied about, what is generative AI as compared to normal or plain vanilla AI. So there are a lot of definitions. None of them are perfect. Whatever I say today, I'm sure tomorrow you'll be able to do a search on your preferred online search engine and find a slightly different variation. But broadly speaking, I'll try and just set out what do we mean by AI. So AI refers to a computer system or application that is capable of performing functions normally associated with human intelligence. For example, abstracting, reasoning, problem solving, and so on. Not my words. This is from a report of the US National Security Commission on AI. AI applications employ algorithmic models. Those of you who use online search engines for a simple Google search to find directions from A to B, you are using an algorithmic model. But AI is a little more than that. It uses algorithmic models to receive and process large amounts of data and are trained. Now here's the difference between a straightforward algorithmic online search and AI. They are trained to recognize patterns. This allows them to automate repetitive functions and make judgments and predictions. So, crudely put, the difference between a plain Google search and something produced by AI is a Google search will retrieve information that is available on the internet for you, whereas AI will take data that it has already been trained on to answer your prompt and make a prediction or come to some kind of conclusion. So it's one step beyond simply a Google search. Another term that we hear often in sort of the light of AI is machine learning. So machine learning is a subset of artificial intelligence. It refers to humans training machines to learn based on data input. Now this human intervention is important. I'm sure Imran and Jasneet will lead us to the pitfalls and the benefits of the human intervention in this training. And via machine learning, computer programs look for patterns in data to draw conclusions. Again, it's more than merely retrieval of data. It's more than just some computer program scraping the internet to give you information based on your input. It's coming to some conclusion. It's going that one step further. And once it learns a particular conclusion from a particular set of data, it will apply that conclusion to a new set of data, right? This is now an automated process. You are not asking it to come to a conclusion and then full stop. You are asking it to come to a conclusion based on a certain data set, then it will apply that conclusion to a new data set. I'm stopping short of using the word reasoning here because that's a different debate. Then I think what is now more relevant to us, and which is where the technology is today. What I've just described is maybe 5-10 years in the past. What is an LLM? An LLM is not a legal degree in this context. It's a large language model. Again, a subset of AI, sometimes also called natural language processing. So this is a field of AI that enables computers to analyze, again, large volumes of text data, identifying patterns and relationships. Now, I'll just give you a very, very crude example. In a large language model, what is happening is that a computer program is being trained to predict what is likely to come next after a certain text. So suppose you were to write down into the input section of a large language model, a man rides his cycle down a hill and hits a bump, right? Now, a normal human might be able to, or rather a natural person might be able to predict what phrase is going to come after a man rides his cycle down a hill and hits a bump. But a computer that is not enabled with AI or is not a large language model will most likely not be able to predict what happens next here in this scenario. LLMs are trained by humans through what I described as machine learning and natural language processing to predict what phrase or sentence is going to follow a man rides his cycle down a hill and hits a bump. So through this process of training, every time the computer gets or the system gets a correct conclusion on the data that is entered, it will apply that to the next one. Now through this process of training, that AI large language model will learn that after the phrase, a man rides his cycle down a hill and hits a bump, the phrase, then he fell off the cycle is more likely to occur, as opposed to the phrase, but nothing happened. So in this way, the computer gets trained that when it sees a man rode down a hill on his cycle and hit a bump, it is trained to predict that in all likelihood, the next set of words or the next phrase is going to be, but then he fell off the cycle. It's not going to be, and then nothing happened. So, I mean, it's a very, very crude example. I'm not a data scientist. Like everybody else in the room, I'm just a lawyer. It's just an interest of mine. That's why, I'm here today. But just to try and give you an understanding of how this works and how this is different to the computer programs or the algorithmic search engines that you're using on the internet work, and how large language models and AI works. Now the last word which you will have heard if you read the news recently is generative AI. Again, a subset of artificial intelligence, which is used to create new content based on training and on existing data taken from massive data sources. So when we talk about big data, this is where big data comes in. The ability to take huge quantities, I mean terabytes of data, right? And use that to train a large language model in order to give responses to prompts from a person. So as an example, the artwork that you see in front of you, this is an example of generative AI in action. It's taken those two prompts, the two pictures that you first see, and used those to generate the third one. So it's something arguably new, right? And so again, like I said, in a very crude way, I've tried to explain what do some of these terms mean. And why is this important, right? Anyone who's read the newspaper recently will know that there's a Chinese company that's come up with a new Gen AI or generative AI called DeepSeek. And because of the open source nature of DeepSeek, again, I don't want to intrude too much on what Imran and Sunita are going to say, you know, it has been able to shave millions and millions of dollars off the worth of companies like Nvidia in the US stock markets. So we're dealing with a topic that's not just new, it's not just useful, but it's also extremely disruptive. And I think that's why it's important that we're discussing this today. Now, in terms of where does AI intersect with the law and why are we sitting here today? To my mind, there are sort of two problems or two issues that rise, first order and second order. Now, a first order problem would be, if you take the example of the audio clip that I played, that was a fairly innocuous discussion between two historical characters who are not here to defend themselves. There's no immediate human harm being done by someone listening to that. But let's replace those characters with our Prime Minister and the current President of the United States of America. Now those people are alive, and if someone was to use an AI to train on the basis of audio clips or recordings of those two individuals, and that was made into a podcast and released to the general public, would people be able to tell that these are artificial intelligence-based creations? What problems would be caused by that? What is the sort of ethical dilemma that arises from something like that? That's a more immediate example of the clip that I played just now. How do you regulate that? When it gets uploaded, let's say onto Spotify, is Spotify required to label that this is a podcast generated by AI so that people know that this is not really Trump and Modi having a conversation together? This is what I would say is a first order problem. We already have in India a lot of issues around what are called intermediaries under the Information Technology Act, right? So at present, intermediaries have a safe harbor provision so long as they don't interfere in how users upload and use information. But what if a user is uploading a generative AI text or audio clip or audio video clip, which is likely to confuse? It may pose a threat to someone's life, It may be a threatening clip uploaded. Will a social media intermediary be required to flag that this content is generated by AI? These are the kind of questions we are trying to pose to you today. Then, now, I mentioned a second order problem. A second order problem, I'll give an example, I think Jasneet will speak more on this, is the copyright issue here. Who owns the output from generative AI, right? If Modi and Trump are around to claim copyright, will they say that the audio clip that you made of us using generative AI, we own the copyright to that? The company that made the AI software, will they claim ownership of the output? Or will it be the person who gave the inputs into the AI program? Will they claim copyright? That if I had not given this particular set of inputs, the AI would not have generated the output that it did generate. So that's an example of maybe a second order problem. Another one that might come to mind is, how do you, in legal jargon, how do you classify AI programs? Will they be juristic persons? Will they be body corporates? Suppose there is something that happens on the basis of some AI generated content, actual harm happens to a person. Will they be included in a criminal case? Will there be some kind of conspiracy charge laid against them? Can they be included? Are they natural persons or juristic persons to be included in criminal litigation? Again, questions which we have to ask ourselves, questions to which we have to start thinking about. And it comes back to that paradigm I gave of, are you, or we rather as lawyers, arming ourselves with knowing the benefits and risks associated with this new disruptive technology. Some of this is already happening. I'll give you some examples. The Delhi High Court has already dealt with suits seeking injunctions against what are known as deep fakes. So you may have read, some of you in the newspapers, Amitabh Bachchan, Anil Kapoor, Jackie Shroff, they have already tried to assert their personality rights in suits before the Delhi High Court against people using their likeness, their image, their audio through generative AI. In the same way you heard the podcast, people have been making audiovisual representations of Amitabh Bachchan, which are completely new. I mean, they're audiovisual representations which Amitabh Bachchan never did, but they're being used for a commercial purpose by a third party. And he's filed a suit in the Delhi High Court. I don't know what the status is. Might know better. Seeking an injunction against the use of that AI-generated audiovisual clip. Some of you may even be surprised to know that this issue has come up before our own High Court. Jindal University had to defend a writ petition filed by a student who, it was claimed by the university initially, engaged in plagiarism because he submitted a essay or a report. I'm not entirely sure, and I think the matter has been settled, so I don't want to go too deeply into it. But he made a submission to the university on the basis of a, I believe, ChatGPT output. So this issue is already being deliberated in our High Court. So I think it's, to my mind, a bit of a wake-up call that we now need to be addressing this. We need to be at least asking the questions, even if we don't come up with some answers, on how is this to be regulated. Is it to be regulated? Or is it that the technology is at a place where if you don't allow it to grow free of regulation, you will never be able to harness its full potential, right? I can give you an example. When the internet first came around, if immediately the internet was regulated for free speech, perhaps we would not have the World Wide Web in the way that we have it today. I think that's maybe something Imran will probably speak on more. So without taking up too much more time, I feel like I've spoken too much already. I'll just introduce Imran. Imran Ahmed Ali is an advocate practicing before this High Court and the Supreme Court with about 8 years of legal experience, and graduated from the Department of Laws, Punjab University here in Chandigarh. He's the brain behind Pro Law AI, so he's uniquely positioned to speak about this topic. A pioneering legal technology startup that is the first to integrate WhatsApp with AI technology, making legal assistance more accessible to a wider audience, irrespective of background and financial capacity. So, Imran, I'll just hand over.
Thank you. First of all, greetings to everyone. Pleasure to have all of you here, irrespective of it being past 4 o'clock already. I might not have been one of you a few years ago. However, to see you, it's a great pleasure and honor. The specific part of this discussion that I have been asked to speak about is the transformative impact of legal technology and artificial intelligence on legal practice in today's day and age. For me, I'm of the opinion that change is the only constant, and if you do not keep up with the times, time is going to go by and you're going to get left behind. When we talk about basic things like landline telephones and the mobile phones in our mobile phones in our hands, this one device has replaced cameras, it's replaced letters, it's replaced keeping a pen in your pocket. When we talk about encyclopedias, I don't know the last time I know someone who bought one, because everything that's available to us is off the internet. I don't know the last time I read a physical newspaper, because my source of information is the internet now. When we talk about these books around us, we need to understand that earlier in time, when someone joined the legal practice, there were a lot of costs involved. You had to create these libraries. Now, this problem is solved to a great extent in today's day and age. However, it is not cost effective. For someone who comes from a privileged situation or a background like ours, it is very easy to say, oh, everyone can practice law. However, the costs involved, the problem of proper mentorship. Not every one of us is as lucky to get a good senior. Now, when we talk about artificial intelligence, we need to understand that this is the way forward because of accessibility. In terms of research, in terms of, let's say, drafting, and I will go over a few legal startups apart from my own, and this is not a promotion. However, a lot of these legal startups are helping budding lawyers and lawyers like me and you. I don't remember the last time I wrote a synopsis on my own. However, I cannot say that that made me lazy. The petition that I drafted, when you get artificial intelligence to actually delve into that particular petition and create a synopsis, it can do it without a bias. When I create an RSA in a few hundred pages, I cannot be very objective because I feel, oh, this is relevant, this is relevant, this is relevant. And I end up a brief synopsis of 1 page comes into 5 or 6 pages. Further on, the bench says that this is not a synopsis, this is a mini thesis. When we talk about increase in efficiency, why I feel artificial intelligence today increases our efficiency is because redundant tasks. Let me give you an example. The first thing that happens to me when I go to offices, I get phone calls of my clients saying, what is your adjourn date? Completely redundant task, is not helping me professionally, yet I need to do it. With the involvement of artificial intelligence, there are softwares that at the end of the day, the moment your order is uploaded on the High Court website, it sends it to you on WhatsApp, it sends you an email, and you have an option of sending that to your client as well. Redundant tasks, completely finished. You can help, you can draft cases, you can research, you can find new clients in meanwhile. When we talk about tailor-made arguments, the ability to go pan-India across the world on one particular type of matter. Now there is a limited extent of how much we can research. There is a limited extent of how much time we can put in. However, when we come to artificial intelligence, it can do all of that in a matter of minutes. You talk about a contract analysis. How many of us who have drafted contracts, agreements, have not asked, the first time we asked or we made a contract for somebody, we always ask someone for a draft. Now, your output primarily depended on who sent you that draft, what was that quality of the draft, because you built upon it. However, with artificial intelligence, you can put in your data set, you can put in your information, you can put in your prompt, and you can get a tailor-made document which will cover things that ordinarily even you could not have. Now, I'm not talking about people who are 30 years into the practice. You have your relevant research, you've done a few number of cases, you've drafted hundreds of these agreements. However, someone who's fresh off the boat, who's fresh off his legal degree, does not have that access, does not have that information, does not have that experience. Petition drafting. If I don't know a single advocate who has been able to draft a petition right from law college without help or without somebody else's draft. Now, I don't mean to demean all of us, but there is a natural progression from studying law to finally coming and practicing. Now, if you are lucky enough to be mentored by somebody who has a decent amount of work, who has the experience, you will get a good draft, you will help your client get the relief you want or they want. However, if you have not been as lucky, you will go around requesting people. Those people might not respond to you, and that will eventually impact your accessibility and your acceptance of the client. Now, in terms of petition drafting, there is a limited amount of things that even a human brain can think about. I'm not saying that you put a limit onto it. However, there are things that we might not ordinarily in the course of normal working think about. However, with artificial intelligence, I don't say replace the hard work. I say supplement it. You make your draft, put in your prompts, and see if there's something you missed out. You will always add on to it. I don't say give it to, because that will make us lazy. If you have somebody else replacing your task altogether, there is no involvement. However, my discussion here is for supplementing it. When we talk about rebuttals, trial court advocacy versus what we practice here are completely different. In terms of, the first thing that comes to my mind is a cross-examination. any individual or any lawyer amongst us who has done a cross examination, there will be a immense gap in your first versus your 50th. That is your experience. Your ability to question, your ability to reason, your ability to respond to counter questions. Artificial intelligence puts you on the same level playing field. It gives you the ability to ask questions that ordinarily would not have come into your mind with only a 6-month practice. When we talk about case management systems, the case management system, I would eventually connect this bridge with what I said initially, which was respect to efficiency. The case management systems, although something which we consider or a menial task where we get probably our clerks to do, however, these are important tasks, sometimes due to human error get missed out on. Sometimes you note, and I don't know a single one of us, and you raise your hand if you've not sat in a courtroom and not heard one of those applications for a case to be relisted or the restitution of that particular case, in which either the lawyer himself missed out on that date, the clerk missed out on that date, and eventually that case got dismissed for non-prosecution. With the involvement of artificial intelligence, that problem never arises. You never cut a sorry figure. With respect to compliance and risk management in terms of corporate litigation, when we talk about the ability to suggest remedies, and remedies, if you practice in one particular jurisdiction versus the entire world, I would always feel that a holistic approach toward these remedies would always be more relevant. Something that I feel is always a question where they say that artificial intelligence is intrusive. Gemini coming into our Gmail inboxes should have been our first red flag. Today there is nothing that we do in the real world, in the real environment, that does not infringe. However, things like yellow pages that were irrelevant today were the norm earlier. The access to justice. Let's think as a client. From one side, I have to bring on board an entire legal firm. Why? Because the amount of those endless work hours that an X number of people have to put in for that particular research. Now, this could be scanning through documents that ordinarily don't need my time, or even summarizing it. When we talk about these long judgments of 400, 500 pages, the objective, the operative part can actually be summarized in maybe 3 to 4 pages, cutting our working time or our associates' working time in office, bringing out only the relevant information that I need to read, or maybe summarizing the relevant information that I need to read. And this can be done without bias. When we talk about, and very kindly my panelist introduced me as somebody as the mind behind a new artificial intelligence software, I feel the accessibility to all is what we all should strive towards. We talk about these publishing houses who have softwares. Yes, those X number of lakhs that I needed to invest into a library, I don't need to. However, that 25, 30, 40,000 is still a lot for a lot of us, and especially for someone who just graduated from law school. Now, most bar associations like ours have computers along with those softwares and paid subscriptions available in libraries. Where artificial intelligence can help you is you find the judgment through artificial intelligence, yet apply your own mind, go to that free computer available in your bar association, download it, read it, and then present it in court. Do not replace your brain. Do not take ahead, like very kindly he also mentioned, that you do not take a fake citation. That would show that you have not read the citation, you have not read the judgment. That is where you go wrong. But if you are able to find the judgment, cross-reference it, download it, read it, absolutely submit it in court. And if you can save hours of time spent on research, I'll tell you how we came about this particular software. I don't come from a law background, apart from my uncle, and my Parents, my brother-in-law asked me, they said, why do you spend so much time in office? Everyone else is 9 to 5, 5:30 we are home. You're working till 10, 11, you've got dark circles under your eyes. I said, our entire process from drafting to arguing to research is extremely time consuming. My brother-in-law asked me, he said, what takes time? I said, finding law, drafting. He said, what, and this was 3.5 years ago, he said, what if artificial intelligence can bring that work time and cut it down by 1/10? Cut it down by 9/10 and making it 1/10. I said, why not? And it originally started as something that was only for finding judgments. However, today in a matter of 30 seconds, you can summarize an entire petition. You can find relevant laws irrespective of whether them existing within your draft or not. You can find relevant judgments. You can find alternate courses of action. And there are so many artificial intelligence based softwares that are available to you off the internet, which will actually supplement it. And the last thing I want to end by, and we'll open this after Jasneet has spoken to you, because she's going to take a completely contrary stance to mine. However, I want everyone to know is that don't consider this as a replacement to your hard work. Consider this as an added tool. Consider this, you think somebody who practiced in this high court in the 1770s or 80s would be lost today by way of our orders being uploaded online, our paper books being available on the e-diary. The first time I was to argue on an iPad, I thought this was the worst idea possible, because you are used to a way of arguing, you're used to standing on that podium, putting your file in a certain way, your annexures, your judgments. However, when you come on to this side and you actually see how easy it is by just a click of an arrow to go into voluminous record, to go into judgments and go into the exact relevant paragraph, you understand and you realize the importance that not everything needs to be manually done and spend so much of time doing. And let's not even go into the argument of wasting paper, because finding judgments, first you read it on the computer, you say, oh, it's relevant. You print it out just before giving it, you read it again and you see it's not relevant. So, there is an objectivity and there is an inherent bias in our minds when we start working towards something. Why is it that when we draft something versus when it gets finally printed into paper, there are multiple errors that actually come up? Is that because when you're so into the process, you don't realize that you need to have an unbiased and an objective approach towards the whole thing. In terms of questions, we will probably go towards it in the end. However, I feel that this is the way forward. There is no replacement to adapting to change. This is change. Use it positively. Use it to your advantage. Don't be scared of it and run away. Because if our forefathers would have done the same, we would be sitting without electricity, without these tablets, without anything. Thank you. Over to Jasneet. Should I introduce you?
Yeah, just do the...
Okay. Introducing Jasneet. She is a co-founder and partner at Just IP. She's got more than 12 years of experience. She has experience in IPR law along with civil and constitutional litigation. After starting her IPR divisions in 2 leading law firms in Delhi, she's set up an independent practice in Chandigarh with special emphasis and in copyright and trademark law. Jasneet.
Thank you, Imran. One could say that I'm a bit of a misfit here because unlike my co-panelists, I've handwritten my notes. I'm still flipping through pages and not scrolling. I'm yet to transition to liquid text. So, but yes, I completely agree that we have to keep up with the changing times, and that is the only constant that has ever been. That is in fact a very famous societal norm as well. And before I start, I just want to say I'm not anti-AI, I'm not anti-technology, but I just have a different approach and a different side to show. Mostly, a legal side, which of course now we have to keep up with the times and we have to keep up with technology, but we also have to understand the changing legal implications with the changing technology, which is not only impacting our profession and how we can use it to our advantage, but also how it might impact our society and how does the law deal with that. So, broadly speaking, there'll be 3 categories that I'll be talking about. One is, of course, the requirement of protection of AI works that are generated by AI, and requirement to protect pre-existing original works being allegedly unlawfully being used by AI. That is like a general legal dispute that all over the globe we are witnessing. The second category that I'll be talking about is the legal and the judicial reaction to these kind of disputes. The third is, of course, the administrative, legislative reaction. How is the executive dealing with this rapidly changing technology and the way it is legally impacting the world? So, starting with the first category, which is protection of works, okay, which will broadly be categorized under the intellectual property rights. I'm sure most of us are aware of that. The specific bracket of intellectual property rights that I'll be catering to now is the copyright law. I'm sure most of you are aware of that. Would somebody like to just give a very, very short and crisp description of what copyright is? Any of the interns here? Just a wild statement that comes to you. What is copyright? What do you think it is?
It's a protection of one's individual creation.
Right. Anybody else? Anybody else would like to say what is copyright? Yes.
Right to protect the literary and artistic works of a creator.
Wonderful. So, in one line, I'll just say copyright is the right to copy. Okay, just the name itself says right to copy. Okay, who owns this right? This right vests with whom? It vests with the owner of the work. If I am the original author / owner of the work, then the right to make copies of that also vests with me. And I can authorize a third person to make copies of that. That can be by way of licensing, by way of a sale. I can sell my work and then that person owns that, right? So this is what copyright essentially means, to just give like a very brief idea. Now when we talk of pre-existing original works, as Gurpreet has already described how the AI mechanism works, right? So they are these tools, especially generative AI. So there is a lot of information, a lot of data that is already existing, whether in the public domain or privately owned, right? They are all available. That is being fed into, in very layman language I'm talking, that is being fed into these AI tools, the LLMs, right? They become a training data set for the technology to work on, to operate on, to facilitate the output, to generate new work based on that pre-existing data sets, right? So this is how essentially it works. Now, the main dispute that is existing all over the world is whether an AI platform can use a pre-existing work which is owned by a third party, right, and use it to train its LLM model to generate a completely new work, right? So this is one of the areas which is under dispute, and I'll also explain in the second category how the courts are dealing with it and what is the actual issue that is happening. The second area in this is the requirement of protection of AI works per se, so which is the output that comes out of generative AI. Whether that can be protected as a copyright or not, that is another question. Now, all over the world, a general rule in copyright and even patents is that a work can be protected by which is created by a person. Okay, so Raghav is one example that Gurpreet has already discussed with you, whereby Raghav is a tool which created apparently an original work. Now, whether it is original or not is of course a matter of dispute. But the fact is that the applicant, which is the owner of that tool, alleges that this is my original work and this is my creation because it is based on the image that I took, and the work that is created out of the AI tool is a completely different work, right? An application is filed. application is filed in the name of the AI tool, that is Raghav, right? But there is an objection raised by the Copyright Office that, oh, this is an AI tool, it is not a natural person, so it cannot be an applicant. Because the legislative intent of IPR laws has always been to recognize, protect, and encourage human creativity, human originality, right? But we are faced with a scenario where, as I said in the beginning, there is an artificial intelligence which is probably producing far more superior works, right? Whether or not they are original is a different question. And whether that can be recognized and protected and registered also, and whether rights in those can be enforced, right? Today, it's just today's news that 2 AI companies are fighting with each other to say that, one AI company has infringed upon the other's AI tool, right? So we've come to a point where AI companies are challenging each other's IP per se, right? So this is one of the broad areas where we see that there is a lot of discussion happening all over the world around this. So Raghav's application for registration of the Suryansh, what was the name? Suryast work was actually there is a withdrawal notice that has been issued by the Copyright Office saying that because it is not a natural person, we cannot allow registration. And I believe that a response has been filed by the actual human applicant to that notice, which is still pending. So we're yet to see how this will play out in the future. But the same work has been refused registration of a copyright by the US Copyright Office. So the same work was also applied for registration in the US, and that already stands refused on the ground that there is no human intelligence, no human originality involved, right? So anyway, so moving on from this category, the second category that I would like to talk about is how the courts are dealing with it, and how are people who are affected by the unauthorized usage of these pre-published and pre-existing works are affected by it. As of January 2025, there are around 38 copyright lawsuits that are related to AI that have been filed in the US alone. And 38 is a big number for a country like US because litigation there is very expensive. There is a lot of heavy pre-litigation procedure that is followed in those countries. Most of the parties do not prefer going into litigation there. But yes, the fact is that there are, as of January 2025, 38 copyright lawsuits pending. Now these include lawsuits that are filed by publishers such as New York Times, by various authors alleging that their original works such as books and articles and research papers have been used and retained without permission to train the LLMs and the AI tools. So when we say retained, you've not only used them, you're also retaining them in your AI tools, in your AI software, and you are using them for the output that you're generating, right? So there are many suits that are pending in the US around this. There are some YouTube influencers also who filed lawsuits to allege in one of the cases that OpenAI, in fact, has scrapped their videos. So whatever influencer videos come up on YouTube, they've been scrapped and used to train OpenAI models. So that is another category of dispute that you can see. Music producers, including Universal Media Group, have sued AI companies alleging copyright infringement of musical works. So they say that in the process of building and operating these AI models, AI companies are unlawfully copying and exploiting vast amounts of original copyrighted works. In India, a lot of you would have already heard about the ANI versus OpenAI case. So ANI has also sued OpenAI in India, alleging the same thing, that its pre-existing publications have been used as training data sets by OpenAI to train its LLMs, right? And again, the same argument is that, it is our copyrighted work, and without any valid assignment or license, this cannot be done by any AI platform. Thank you. What has happened just very recently, in fact, in the last 2 days, is that the Digital News Publishing, which is an organization recognizing the interests of all digital media publications, has filed an intervener application in this suit, which is pending before the Delhi High Court now, to intervene in the same dispute, to basically put forth the right of other media publications also, whose works are also being used as training data sets by these AI companies. Interestingly, Times has not been a part of this application, and it is apprehended that Times plans to file a separate lawsuit against OpenAI. Just as of yesterday, OpenAI has filed its defense in that pending civil suit, saying that India, in fact, does not have the territorial jurisdiction to decide this issue because OpenAI has no office in India. So they say that Delhi High Court is not a valid jurisdiction, not a valid forum for the court to decide on this issue. However, the counter argument, of course, could be, the effects doctrine, right? So all of us are aware, defects doctrine is a doctrine which basically says that if the effect of that cause of action is felt in that jurisdiction, then of course, yes, the court has the territorial jurisdiction to decide on that matter. And of course, we'll have to see how that litigation plays out, right? Because it's evolving and there are new developments happening in that matter every now and then. So, yes, so broadly speaking, these are the kind of disputes that we are now seeing between AI companies and right holders, I would call them, because they are the right holders of the original works, which are being exploited to gain commercial advantage by the AI companies, right? Now, in most cases, there might not be a license. Also, we have to understand that AI is a completely unregulated space in most jurisdictions right now. So there is a tendency to obviously take advantage of that situation. Coming on to the administrative slash executive slash legislative reaction to these kind of matters. Now, up till now, there is a broad understanding, I think, amongst all people, is that broadly speaking, AI could fall under, as I said, copyright, it could fall under IT Act, Information Technology Act, it could fall under, Digital Protection, Data Protection Act also, right? There is no specific legislation, there is no specific rule, there is no specific regulation guiding, how this dispute structure can be resolved. Very recently, what has happened is that MeitY's subcommittee has issued an AI governance report seeking comments and engagement from all stakeholders. And when I say stakeholders, I again refer to not just AI companies, but also right holders, right? People whose rights are bound to be affected by AI, for instance. While this report, and I think most of you have copies of the report also, we've just taken the effort to share it. It's a short document. All of you are free to take it home and read it, but I'll just give a brief outline of what the report talks about. It lays down certain principles relating to transparency, accountability, privacy and security, and several other issues relating to AI and AI exploitation in India. The report even mentions concerns relating to deepfakes and malicious content, as Gurpreet had highlighted earlier. It also talks about cybersecurity and IP, and also recommends certain measures, Broadly speaking, I would say that while the report can be said to be a first formal note of executive acknowledgement of global AI developments and impact on India, I think it falls short on a lot of factors, and I leave it to all of you to independently assess what it could have done more. But broadly speaking, if I were to say, I feel that the report does not talk of any global legislative changes and best practices which can be adopted in the Indian ecosystem as well. While it mentions key issues such as impact on IPR, but it does not delve into detail into these single aspects. It very superficially covers these points. It does not mention any real-time measures which the government is adopting to counter these AI issues. There are no suggestions, there are no measures to establish any independent regulatory body or structure a legal framework to handle AI incidents and systems. While it briefly mentions the Digital India Act, which is touted to replace the Information Technology Act, as most of you would know, but again, it falls short of talking about how tomorrow, if Digital India Act is introduced or enacted, how it could deal with these kind of scenarios in the future. This is a very different scenario from, again, I go back to US to draw a comparison. But just to give you an idea, there are already many bills introduced in US to deal with these kind of scenarios. I'm going to give 3 examples to just give a broad understanding of the extent of legislative intervention is probably going to be required in this space. The first bill that I want to mention is the Generative AI Copyright Disclosure Act, which imposes responsibility on AI owners to disclose all training data sets involving copyrighted work, which is used to develop and function an AI tool. So again, the responsibility falls on the AI innovators, the AI companies, the AI developers, and not to mention Imran here, but generally talking of AI companies, to disclose the training data sets that are involved in using the copyrighted work, and which is going to, facilitate the AI tool to generate the output. So this is one bill that is already pending. The second is Protecting Consumers from Deceptive AI Act, which would probably cater to a situation like a deepfake situation, which all of us have already read about and which Gurpreet mentioned earlier. Third such kind of bill is AI Consent Act, to address personal data privacy concerns. So these are broadly 3 kind of bills that are already pending for in US, Whereas in India, I don't see, besides this report, this regulatory report, there is really no proactive legislative change that one can foresee right now. I'm going to end with one thought, which I feel could structure the way forward, especially when we talk of resolving the dispute between AI companies and right holders, and to find like a middle ground where, ultimately, as even Imran said, it is a tool which is to benefit all of us, right? For us as lawyers and even for the society, I think. But the fact that it has to be used ethically, legally, and in a very right manner without exploiting a third person's property, right? If we are to find a middle ground and if we are to eliminate any kind of potential litigation, I feel licensing is the proper way forward, where there is a licensing regime established. Who knows, tomorrow we might see compulsory licensing coming in this also. There is a concept of compulsory licensing in Copyright Act, right, which primarily caters to musical works and cinematograph films and all that. But who knows, we might see it here as well for literary works, right?
Radio industry operates.
Yeah, completely. So you never know that this might happen in the future, and I really believe that licensing can resolve a lot of these disputes. In fact, OpenAI has already entered into a licensing deal with Financial Times, where they are using Financial Times published works as training data sets in a very legal, ethical manner without violating their IP, right? And I feel that the fact that they enter into that licensing model sort of shows that they acknowledge the fact that they are required to enter into a licensing. Okay, Arjun disagrees with me, maybe we can hear you out on that. But I feel that it is a tacit admission that yes, a licensing is a proper way of going about it. And in fact, I feel that a lot of litigation in US might get settled because it's a hard battle for both sides to pursue litigation, and they might just come up with some kind of licensing deal to close this, right? So I'm just going to leave it at that, at the thought of something benefiting both parties, the original creators, the humans, and the technology. So I'm just going to end it at that, and we'll open it to all of you for discussion. Any questions? Arjun, you might want to clarify.
We're on
Thank you
YouTube.
for this nice discussion, round of discussion. Well, taking cue from Imran, there's a beautiful quote on internet. I don't want AI to do my art and writing. I want AI to do my laundry and dishes so that I can do my art and writing, basically. So I have three questions. One, Mr. Singh, you had talked about a proposition whereby the people are stressing on those personality rights, basically. I was just wondering how different are those from the propositions. For example, if I may quote, a mimicry artist mimics, say, an actor, does an act, he writes it. In that case, in the real life scenario, does that actor can impress upon his rights as a personality, or does it even only apply to the scenario of copyrights, and like that, how does that proposition comes together? And second is, I'm curious, if is there any instance where an AI based process has been sent for patent application ever? Because what patent makes different is it is about a process. Has there been an instance where AI has come up with a proper, you know, a model of something which is exploitable and sort of a novel in a way, and patent application has come? Third is about, now deep fake is another example where you know, the voices and the act or the persona is used to deploy to convey something. Now the kindly pardon me if I may say that we are living in very polarized regimes right now, and God forbid if something incites riots or something like that, deepfake does that. So does existing law, I don't think it does have, but is in the draft, is there a space where this discussion can be brought in?
I'll just... Hi. So thank you. The very relevant questions. I think the first two questions maybe Jasneet is probably better equipped to answer. The last question you asked about whether a deep fake in some audiovisual form, or maybe even just in an audio form, could somehow, if it actually does some real
already hard to someone, what would be the implication of that? Cheat a bit. Put the question back to you. As far as I'm aware, perhaps the provisions of the IPC which may cover that situation. Only impersonation as an offense is there. No. So the question is, if your act of impersonation incites a riot, right? Then it is covered under PLS right now. So, but I am contemplating situation whereby, say, an AI generated audio play. Just one second. I think since we're getting this recorded, if you could use the mic, then everyone would have the benefit. Yeah. So my question actually, I'm not talking about impersonation as an offense. It is already there. Person impersonates a voice, incites violence, it is punishable. I'm saying an audio is found to be there on internet. We don't know who is responsible for its generation, but it is AI generated. So I'm just seeking the space of such a provision, or even in the existing laws of the bill which is pending before the law. Are they even going to that extent to the penal consequences? Basically, that was my query. Okay, so one, there is no bill pending per se, right? We are working in a sphere where the answer to your question, I don't know the exact provisions, maybe someone in the audience will be able to answer, probably already lies in what is the Information Technology Act and the current version of the Penal Code. I think Arjun would probably be able to tell us better. How is different code that but it's highly inflammatory, and that it is easy. I would answer is perhaps it will not treat it differently. But these are questions that have to be answered. So, basically, that's simple. This sort of simple answer. I'll ask Arjun maybe basically audience he can get the right thing is paid for it.
question after giving with question. So, similar scenario regarding application to be filed by an actual person. The word natural is not used, but that is bit impolitely accepted by the areas precedents now. Is that it has to be a able applicant. Right? If application you have, if it has to be a you person. It cannot be a company. Yes, it can be an assignment by an individual to a company, and then the company can everything be the application with the patent application. So the same concept. But even as an individual, file for a patent of an existing AI tool, in API till say 5 months ago, I say that I would say bad, but if they show some kind of technical effect without it being applied or integrated with the hardware, then that software on its own can be fight for as a patent. Before that, what was happening was that an integration between the software and hardware was required for it to qualify as a patent. That provision has been slightly liberalized, I would say. So in India, the approach is changing a little bit. The IP office has become a little bit more open to these kind of applications now. What is happening in the US is a little bit different. So US has been open to these kind of applications without any requirement of any integration with the hardware, etc. And yes, nearly applications for registration of softwares, including AI, are being permitted. And people know if any such patent is going granted.
Softwares are technically copyrighted. So the code is copyrighted.
So what is protected under the Copyright Act is the computer program. Okay, but patent requirements are different. There is a slight overlap, but yes, what you get in return as a registered patent vis-a-vis a registered copyright are two very different things. But I don't remember the first part.
So that personality bit, like for it, weakness,
Be modulated by an AI tool, right? Now he's not here to defend himself, as he likely said. And unlike US, where they have a Personality Rights Act, in India we don't have such statute. Courts have interpreted personality rights to not be exercised posthumously. Okay, so a person who is no longer living, his estate cannot assert those rights. So in this kind of a scenario, there is no action that anybody can take. Unless and until that, okay, so here also there can be two scenarios. Unless and until what Nehru is speaking is actually an original published work which is, then the publishing company and take the action that yes, you are exploiting it. So that is a different subcategory. But if a personality living, their work is expert, their voice is portrayed. Arijit Singh's Bombay High Court case is very famous. His voice was modulated by a lot of AI companies. Right? He appealed to the Bombay High Court and he said he got a John Doe order. I don't know if
He said he got a John Doe order. I don't know if most of us are aware. A John Doe order is basically an order against any unidentified third person, saying that this third person website or this third person is exploiting my rights without my authority and without my permission. And a John Doe order is issued, right? Yeah, in India we say Ashok Kumar orders because unlike US, everybody is a John Doe, here everybody is Ashok Kumar. But anyway, so Delhi High Court goes a step forward. Delhi High Court issues dynamic injunctions. Now, dynamic injunctions, because Delhi High Court has the concept of JR. I think most of us are aware of that, joint registrars. So what happens is that once an ad interim injunction is granted, protecting personality rights of a personality, right? Say a John Doe order is passed, matter is delegated to the joint registrar, and in the order it says dynamic injunctions. So what happens is that tomorrow during the pendency of the suit, if any third party, if I come across any third party infringing upon the same category of rights, then I can just file a miscellaneous application in the same suit before the joint registrar and the same order will apply. So that is why they are called dynamic injunctions. So yes, the law has really it's there's no statutory law as such, but I think the courts have very broadly and very liberally protected rights already. So as Gurpreet said that without there being a statutory law in place, also there's already strong protection being granted by courts, Bombay High Court and Delhi High Court, and even our High Court in a few matters, where we can see that people are able to enforce those rights. And they are able to make out a case that their original works are being violated through AI tools.
In terms of just supplementing that, what better way to give you an answer supplemented by artificial intelligence in itself? You asked for the specific provisions of law. 316 BNS, cheating of personation. 317, punishment of cheating by personation. 337, 339, forgery for cheating. 354, defamation. IT Act 66D, 66C, 67, 67E. This is the ability of artificial intelligence. Answers that you and I ordinarily would not have had, we have in 15 seconds. Don't make this your only source of information. However, when you are caught in a sticky situation like we were upon his question, find artificial intelligence supplementing your answers.
Just to round off. Exactly. Make sure you read the provisions. Make sure they're not hallucinations by the AI.
Yeah.
And just to round off the answer, so in the US, personality rights are a species of tort, right? The way that you enforce a personality right is as a species of tort. There are some states where they have formalized that tort into a statute, but it is still a species of tort law. In India, it's similar. We haven't, for whatever reason, legislated on the tort law aspect, but it is a species of tort. You will file a tort injunctive suit. Yeah. Yeah.
Small intervention. I speak as a user of AI and not as an IP lawyer who would be fighting for right owners, etc. I speak about someone who started using Google in the late 90s, when Google also faced the same thing. First time you know, search engine, which when you search for an answer will broadly point to where the answer lies. All material used to be IP protected. All websites were IP protected. But for the first time, it organized the knowledge of the world. Later, we had Google Books, which organized the Google Books knowledge also. And today, we are so comfortable with a free system where once you search, you get all the answers. I think AI, the only reason AI has picked up so well after 22 is not, it didn't start in 22. ChatGPT was the first time it became accessible to all of us. It was free, it was easy to use, and it's mind-blowing, right? So I would say, great, you have your regulation, but don't kill the golden goose. It's too early to start regulating so much, having a licensing regime that makes it so expensive for, one of the speakers talking about accessibility and the lower cost. Instead of spending say 30,000 on a law finder software, why not get a software or any other AI-based software? Think about this. If every book owner or a book author, everyone who's written a song, every YouTuber who's given a video has to give a license to OpenAI or any of the open source softwares, what will the costs be? Will we even be able to access such a software? Remember that pre-ChatGPT, there were these legal softwares based on AI existing with the top law firms in the US and others, worth millions of dollars, and we had no access to it. So let's talk about the democratization of that bit also. And the new Chinese model, I think DeepSeek has made it open source, and you see the changes that will be brought in because it's accessible and it's free of cost. That's one. The second thing I'd like to say, as a user again, in our firm we've been able to use ChatGPT and other AI, and it's been brilliant. But we've had interns, for example, giving me Chhattis High Court judgments which either weren't relevant or didn't exist. So that is a caveat which all of us should be using. We started using AI for dictation. There are some great software called Mac Whisper if you own a Mac, and I think you can dictate whatever you want to dictate, and it will even transcribe things which are in Hindi, Urdu, Punjabi, and 50 more languages. I mean, this is this is something which never existed without having access to really expensive software or resources. So while we talk, while two of the speakers are IP lawyers and come from the copyright regime, I as a user would prefer the copyleft regime, where all this is public knowledge, which is accessible to everyone. So if in this library I am able to read maybe 10 books and write an article, I don't have to get a license for maybe one of them, right? Similarly, if AI is able to help me as an intern or an assistant is great, even if it refers to 2 million books, because there are too many books, and if AI is able to help me in that process, and I acknowledge that AI was there in the process, then why not? I think that should be enough. Yes, there is a serious concern when OpenAI is a $50 billion company suddenly, and how did it get there? I mean, let the US courts decide all of that. But as users, let's freely use this software. And as I said, it's a great servant, a great assistant, but a very poor master. So just use your brains.
Yeah, so I agree with that. Two things that you said I agree with. That of course AI will be what you perceive it to be and how you use it, right? The second thing which you said, right to access to knowledge and information, right? That in fact is a very important facet of copyright law. And all the other things that you spoke about very fairly, that we should use tools that are available for training, for imparting education, for instance, and for things that are scenarios that are covered under this concept of fair dealing and fair use, right? So these exceptions to exploiting protected works are already there under the Copyright Act. If you are commercially exploiting for your profit, for your commercial gain, for your personal gain, then it is infringement of copyright. That is what the law is. And whether you and I like it or not, we cannot go against the law.
I'll just add. I think Arjun made some really good points. And in fact, I alluded to that in the opening speech. I said, do we want to consider at this stage regulating AI to such an extent that we maybe extinguish what is essentially still a nascent industry, right? Maybe, somewhere we all have to consider where is the balance, right? I mean, I don't want to sound like I'm holding a brief for copyright holders, but the fact is, copyright, when it was introduced way back in 1800 or whatever the Statute of Anne was, it was introduced to protect rights holders because there was a legitimate interest that they had. Now, again, as with everything, things lie on a spectrum. It could be, I would probably agree that in the 90s and the 2000s, maybe on that spectrum of rights, we shifted too far to one side and maybe there has to be a rebalancing. But I think one way of perhaps looking at it is, in the US, when you deal with any copyright issue, one question that US courts ask is, of the infringer, your use of this copyrighted material, assuming it is capable of being copyrighted, is it transformative? Because one of the immediate defenses that an infringer will have is, look, my use of an underlying copyrighted work is transformative. What I have produced is something so different, so original, that now it is so different from the original, right, that I have a separate right in it. So if you look at the example that you have, the Raghav AI copyright registration example, let's assume, I mean, he was smart, he probably used his own picture, this Mr. Seni, right? And he used Van Gogh's painting, which is now outside the scope of copyright, to escape exactly this point. But let's assume for a second that he does use something which is under copyright. Would he, and this is a question we have to ask ourselves, I don't presume to have the answer. Would he be able to say, look, even though I'm using two copyrighted source materials, what my platform, which I have written the code for, has produced is something so different, so innovative, so original, that it is now quite different to the source material that was used. I think maybe that's one point to think about. I've been told that your time is a bit short.
A little bit suggestion, because we are talking about all this literally about the last, but I think that there should be a demonstration how to use AI.
Absolutely, I think.
Without that, it is just theoretical. We cannot be successful in understanding.
So what we can do is we can actually request Vidhi Talks and the Bar Council of Punjab and Haryana to give us another hour. Otherwise, some of us, we would move from deep seek to deep sleep. The others.
No, none will. It is very, very good. I'm here not to know anything about the law connected to AI. I think
See how it's
someone
used.
is demonstrating.
Yes. So maybe we can have another session whereby we can put a projector and we can actually go through the softwares that are available and the AI intelligence that's available to us online. So we'll request the same.
It is available in the library also, na?
What is available in the library? Yes, the internet and the publishing houses softwares like Chavla's, like SEC Online, that is available. However, I agree with you that these software should also be made available across the bar free of cost. So maybe we can talk to the bar council and to the association, and
Why
at
not
least
to our High Court Bar Association?
Exactly.
They can say, they can avail it.
Yes,
But because
our
it is a need,
association.
not only we are collecting and others are not here, they
In
may
fact-
have some reason, but that is to be taught.
In fact,
Just
every
like
person-
e-court services,
Yes.
it is requirement of every person.
Absolutely,
Because those who are not very familiar with this online conversations or litigation, they
Absolutely.
need it from A to Z.
Absolutely.
Just
I
like
think-
earlier banking was not updated, now
Right.
that is, our profession is much in need of
Absolutely.
this.
Absolutely.
Thank you.
In fact, what we can actually do is that every person who comes in campaigns, we can actually tell them that if you come on board, this is what we want from you.
I'm here not for my
No,
campaign,
not
sorry,
you. I mean,
please don't
generally
mind.
everybody else. I'm saying, जो भी campaign करने आता है, we tell them that we want this. That if in case you get elected and you come, you please get this done for us.
Sure, I must do this. I
Yes.
need myself. I
Absolutely.
feel all the seniors also need this. We
Absolutely.
all the youngsters here, I think, very familiar to all these things. But the seniors are not. We have to depend upon munshis and they are better than us. Honestly speaking.
Okay.
So we need this.
Thank you. Thank you.
Thank you. I think I've been told now we need to have a hard stop. So thank you everyone for coming.
Thank you.